Yes, Mr. Mnisi, let's proceed then.
As it please the court, my lord. Otherwise, that is it's not a big point. Thank you, my lord. Now, Brigadier, thank you, and good morning to you.
Good morning to everyone.
Thanks. Now, you make mention of the fact that, remember yesterday I said when you spoke about the presentation that you made to the office of the DPP, it would have been something that would have happened in the boardroom, you guys sitting around the table and you making an exposition of the investigation, and then you said, no, it was in the form of a memorandum, not so. Thank you, Brigadier. Now, what was the factual, what were the facts that you presented in that memorandum on which you requested the state to make their decision on?
As a please, my lord. We don't mean to interfere with my colleague's cross-examination, but yesterday at length he canvassed this issue, which in our view, it's irrelevant. And secondly, my lord, what happened when Brigadier Gidinda briefed the office of the DPP, it's irrelevant. It's a collateral issue, my lord, that we submit in our view should not be canvassed during these proceedings. It's like what happens during consultation, you know, it remains there, my lord. It shouldn't be brought into the courtroom.
That is misinformed, my lord. Remember, that briefing or that memorandum is the basis why this trial is happening. So there's nothing secret about it. It could have formed the basis why these accused persons were ultimately arrested and charged with the offenses that they were charged with today. So there's nothing irrelevant on that. Yes. We are entitled as a defense, and more particularly these accused persons are entitled to know what were the facts upon which the state decided to indict them to come and stand trial before this court. What is wrong with that? They are entitled to. Yeah, unless there's something which is being hidden.
Dr. Sibana just reminded me, my lord, that the late Mr. Mgomezulu made Brigadier Gininda to read through his affidavit on which the application for a warrant of arrest was based. So the information is already before court.
My lord, I'm not talking affidavit here. I'm talking the factual basis upon which the state decided to arraign these accused persons to come and appear here. I don't know what was contained in that memorandum. All that I want to get from this witness, who is the lead investigator on this court, what is it that, what were the facts that he laid before the state on which he requested the state to make a decision on, which later on then the state indeed took a decision to arraign these people, this accused person, to come and appear here before court. There's nothing untoward.
Yes, sir.
Before you start, Brigadier, I'm going to request you to take it point by point, because I'll also be taking notes here. I'll be very wary if I were to hear you saying something very long, which I'll end up being confused and coming back to you. What is it that you're saying there? Just take it point by point up until then you say, no, yeah, I'm done. Do you understand, sir?
I do understand, my lord, but obviously the difficulty I may have, I'll try to summarize because I don't have the memorandum with me, and that was done in 2020. But I do have a recollection of what it contains. So insofar as what it contains, I will go slowly so that Advocate Mnisi can write and take notes. But,
yes,
but it will be a summary of what I recall, and then I'll refer to those points, my lord. Now, my recollection, my lord, is that in the memorandum, you first indicate the background of the case, what transpired. For example, now you'll refer to the incident that took place on the 26th of October. So it's a summary of what happened in the case. You summarize those facts. And that's what I did. And then you indicate as to where the investigation led me to, and specifically led me to accuse 1, 2, 3, 4, 5, my lord, before court. Then under accuse number 1, my lord, indicates the evidence that we have collected at that stage that was contained in the docket. That will talk to confession statements that were made by witnesses that we had at the time. Under accuse number 1.
The second. Thank you.
The same exercise, my lord, will be embarked upon when it comes to accused number 2, 3, 4, and 5. So under each and every accused name, I will indicate the evidence that was collected under that accused that we have that connects that accused to the case. So the same principle was applied with accused 1, 2, 3, 4, 5. In other words, we'll have accused 1, evidence that connects him to the case under him, accused 2, right up to accused number 5, my lord.
I'm sorry, Brigadier, those are not facts. I'm going to request the court that if needs be, you go get your memorandum that you submitted to the DPP and then it be made available to us and then we work on it. Because now I don't know what evidence are you saying you had in respect of accused number 1. I don't know what evidence you're saying you had in respect of number 2. But then you're saying that is then the process that I also embarked upon. I want facts, which you presented to the state.
My lord, issues such as the memorandum or the summary of the case by the investigating officer are filed in the B section of the docket and are privileged. They've got nothing to do with the information that is contained in the A section of the docket. We submit, therefore, my lord, that the defense is not entitled to, not that there's anything to hide in the memorandum, just the issue of legal principle. They are not entitled to information or documents that are filed in the B section of the docket. But secondly, and more importantly, counsel says he wants facts. The facts have been presented before court by way of affidavits. We submit that it is therefore unfair to expect of this witness now to regurgitate facts that have already been presented before court.
As it is the court, I think probably it eludes the state's attention or mind that I'm doing cross-examination on behalf of accused number 1. I am his new counsel. I don't know what facts were presented here on record, which is the reason why that witness is there, to assist me, to assist the court. But again, I emphasize, my lord, there is nothing privileged where an investigating officer prepares a memorandum and says to the prosecutor, on the basis of this memorandum, can you please make a decision on whether you want to prosecute or you don't want to prosecute this accused person? What is privileged about that?
The amount of desperation that was in that courtroom today, it literally stinks. I don't know if you guys got to catch it. If you missed it, I saw a comment that said all I saw was Baloyi reading. Make sure you stick to the end of this video because you get to see why Baloyi had to read, and it was session Funda Baloyi Funda. Let me tell you, it was a moment of desperation. All Mnisi wanted. I mean, court was going so well on Monday. Court went very well on Tuesday. And then Wednesday, oh, drama strikes. The judge, Monday, Tuesday, kept holding his lips. You could literally see he was holding his lips together. But then it all came tumbling down today. All Mnisi wanted was for Brigadier Bongani Nicholas Kinenda to just tell him what were the facts that made you to decide to indict, okay, to arrest the 5 accused, but most especially, okay, accused number 1. Baloyi rose up. He couldn't believe that Mnisi could ask such a question, and he said, no, this has already been traversed throughout the session. And Mnisi says, I don't care if it has already been done. I need to remind you that I am the new legal representative of accused number 1. I think it eludes the state that I'm doing cross-examination on behalf of accused number 1. I'm his new legal representation. I don't know what the facts were presented here for accused number 1. And then he continues back to Gininda, asking him for these facts. Gininda's like, listen, I don't have them before me. I'm going to have to give you a summary. And then it was just downhill. It was just downhill. What a painful thing to watch the desperation of the state. And I hate to say this, assisted by a whole judge. A whole judge went ham today. It was a sight for sore eyes. I need you to see this. Let's go ahead and watch when the judge descends into the arena. And after he descends into the arena, you will see what ruling he makes, how he belittles Mnisi. I mean, you know what? We'll catch up in the comment section. I'll be back with the rest of my commentary after this clip. Okay?
Have you read? Is it section 279 or 179? Mr. which makes
It's
Batohi
179.
decide whether to pursue a prosecution or not.
Yes.
So this witness can't help us because that evidence paid itself in court here, which evidence was read to, it was Johnson. Who was the guy then? The guy who used to call Sean the Shipman. What's his name?
Sean Abrams.
Is that the one who decided?
No, it is the current NDPP.
Oh, Batohi.
Yes.
Yeah, fine. So Batohi goes over that evidence, and the decision is his, not this gentleman.
No, but look, maybe
just
thank
listen to
you.
me. And it's a misnomer to say the state doesn't have privileged information. What this witness discusses with Batohi is privileged. The same thing as what you discuss with your witness is privileged. And that is the law.
My lord, I am saying the basis, the facts that he submits to the DPP or to the NPA and requests them to make a decision on, we are entitled to know that. And that is exactly what I'm requesting this week. And my lord, let us for a moment assume that that is privileged. He said he submitted, he made a presentation to the NPA and requested NPA to make a decision on. He did this, in this instance, he did that in the form of a memorandum. I'm simply requesting him to tell me the facts that he presented to the NPA, which facts have got to do with these accused persons that are before court here. They are entitled to know what is it that Glinda told the NPA about us, which ultimately the NPA then decided that we should be arraigned for trial here.
Okay, let's hear you. I mean, I don't also waste time. Let's hear Bininda.
Maybe just one aspect, if I may be so presumptuous as just to mention that, to respond to one aspect. Counsel says he wants to know the facts on which the decision to charge the accused was based. That decision was based on facts contained in the docket. And he has been furnished with copies of the statements, copies of the docket on which the information to charge the accused was premised. Nothing more, nothing less, my lord. He already sits with the information. I cannot fathom why he would want a summary that an investigating officer makes for himself and for the purpose of briefing the DPP, that he should have sight of that when he's sitting with the statements on which the decision to charge the accused was based.
Yeah, okay.
As it pleases the court, my lord. It is so that we have a docket, but there is nothing wrong in me, while saving that docket, to request this witness to give that factual basis or to give the facts on which he approached the NPA. This is cross-examination. The state cannot simply assume.
You know what, I'm going to overrule you. I just read 179. Let's read 179.
Then I'm not going to proceed.
Just read 179.
Well, the heading says prosecuting authority, section 179, subsection 1.
Yes.
There is a single national prosecuting authority in the Republic, structured in terms of an act of parliament and consisting of a national director of public prosecutions, who is the head of the prosecuting authority and is appointed by the president as head of the national executive, and B, directors of public prosecutions and prosecutors as determined by an act of parliament, subsection 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. I think that's what the court has just referred to. Subsection 3, national legislation must ensure that the director of public prosecutions, subsection A, are appropriately qualified, B, are responsible for prosecutions in specific jurisdictions, subject to subsection 5. Then subsection 4, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Subsection 5, the national director of public prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice and after consulting the directors of public prosecutions, prosecution policy, which must be observed in the prosecution process. B, must issue policy directives which must be observed in the prosecution process. C, may intervene in the prosecution process when policy directives are not complied with. And D, must review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified in the National Director of Public Prosecutions from the following: Roman figure 1, the accused person, Roman figure 2, the complainant, Roman figure 3, any other person or party whom the National Director considers to be relevant, subsection 6, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. And lastly, subsection 7, all other matters concerning the prosecuting authority must be determined by national legislation. That is the sum total of section 17.
Yeah, you can answer that if you think you can. But what the law says, there has got to be litis constantatio before a person can be charged in a court of law. In other words, the accused himself must plead. And when he pleads not guilty, then that is the commencement of the case. And if the accused or his counselors believe that these charges are frivolous or they are brought for a malevolent reason, then he brings an application to court for the judge to decide whether in fact there is evidence, prima facie evidence upon which a person may be charged. So even Batohi doesn't just read. He inspects the docket, he goes to the law because this is what guides him. And only after that does he charge a person. And the law specifically says a director of prosecutions may not charge a person if there is no sufficient compelling reason. Okay, you can answer Mr. Mnisi if you are able to. That's what the law says.
May I just assist the court, my lord?
No, you don't assist me, please. I've told you what the law is. Don't assist me.
No, I'm not.
If I'm wrong, take me on appeal, take me on review, fine. But I'm saying this witness, you can cross-examine him on that very aspect.
Thank you, my lord. Thank you. Thank you, Brigadier. I said I'm requesting the facts that you presented to the Office of the Director of Public Prosecutions on which you are requesting them to make a decision on these accused persons.
We hear Mnisi speak on, it is not a privilege to ask for a memorandum. You have got to be kidding me. These guys are arrested. What are the facts? Why is everybody acting like I'm asking for something impossible? And then the judge says, no, Baloy, read section 179. And then Baloy says, Mnisi says, there's nothing wrong with me asking for the facts. And then the judge says, you know what? I'm done with you guys. I'm tired. I'm going to overrule you. Just read section 179, Baloy. And Baloy says, this is my time to shine. Funda Baloy, Funda. And he reads and reads and reads and reads and reads. I'm sure he's so happy. He's like, whoo, we're skipping past that. Woo, we dodged a bullet there. And he's reading and reading and reading. And then, under his breath, Mnisi says, let me know if you heard it. Mnisi says, I'm not going to proceed then, my lord. Ooh, that is how heated this was. But nobody heard him, okay? Nobody heard him, but I heard him. I heard him. Because Baloy didn't respond to that. The judge didn't respond to that. So then the judge then says, did the accused themselves plead not guilty? If they pleaded not guilty, then you place an application before the court and then all the charges are thrown if you think that the charges are ridiculous. And you know what? And she says, may I assist the court? Woo! Those words enraged. They didn't anger. They enraged the judge. And it brought back memories of Advocate Ngomezulu when the judge started throwing his fingers and saying, Rose! Rose! Rose, go get the 3 dictionaries and we're going to define colluding. But in this case, the judge said to Mnisi, no, you do not assist me. How many times do the advocates, do the state continuously say, we are here to assist the court. We are here to assist the court. We are here to assist the court. And then Jiggy Jiggy today, he's very angry. No, you are not going to assist me. And then he says, if I'm wrong, take me on appeal. Take me on review. Fine. Woo! What a morning. Let me know your thoughts in the comment section down below. This was crazy. Thanks for watching. I'll catch you on my next upload. Bye.